All right, guys. Hello, hello. Hi, back. Today we're going to have live with me, attorney, immigration lawyer Alena Shautsova. We're going to be discussing parole in place news, right? What happened with this parole in place program that we were all waiting since June, since probably June, right? When it was announced. And we were waiting for applications to start, and we were filing applications, and we were so excited. And what happened to it? Now, what's going on? So, I'm going to share with you my thoughts on what's going to happen with parole in place. Later, of course, we all can rewatch this video and we're going to see if I was right now or I was wrong, right? And you can comment and let me know what you think is going to happen. So, please join me. Please like, share this stream. And of course, in the end, I'm going to be answering your guys' questions. So please don't forget to type up your questions so we can discuss any topic related to the United States immigration that is of your interest. What you want to know about the United States immigration, what you want to ask. Here, I cannot give you a comprehensive consultation, but I can give you a tip or two and explain some points of the United States law and provide my thoughts on what you can do in this and that situation, or your friend can do in this and that situation, just to direct you to make your life a little bit easier so that you will be able to navigate the waters, very rough waters of the United States immigration law, right? Every day I consult people as to how they can get a work permit, cannot change status in the United States, how to get a green card, what to do with the asylum cases. And I've been doing this for 16 years in the United States. I have a very busy practice and I have very busy, very participating social media. So I have lots of experience dealing with about any and all questions. And on Tuesdays and Fridays, I have these live streams where I share the news, my tips, I provide my tips and how to deal with different situations and answer your questions. So, federal court blocked Biden's parole in place program. How did they do that? Well, of course, opposition sued Biden administration, stating that Biden administration exceeded their power, and for that reason, citing public benefits and so on and so forth, the program must be stopped. Which federal court ruled very fast on that application and stopped it yesterday, August 26th. If you recall, the program was opened for acceptance of the new application starting August 19th, and everybody rushed. I hoped everybody rushed to submit the applications. We certainly did. I had a number of clients who we were working on for months prior to August 19th to make sure that we're going to have those documents and application ready. And we were able to file the cases. And as early as August 21st, we started receiving approvals so fast. Not for every case, but for those cases where USCIS had biometrics on file from other filings. For example, I-601A, provisional waivers. So things were doing fantastic. But then we started receiving news that Texas, it's always Texas, is suing Biden administration for this wonderful program. And who they're suing? Well, they're suing Biden administration, but they're really suing those families that finally had a chance of fixing the spouse's status in the United States. And not just people who recently arrived. We're talking about spouses that by the qualifications for this program has been residing in the United States for a decade, most likely have children in the United States, pay taxes, because one of the conditions for this program is to prove that you resided in the United States for 10 years. How do you prove it? With taxes. So people who didn't have any paper trail, they couldn't even participate in the program. So these are the victims of this hold. Families of the United States citizens, parents of the United States citizens who've been paying taxes in the United States, and now instead of receiving, for the first time in about 20 or 30 years, a break, they receive this hold on their opportunity to really put their life together. And this hold comes from the Republicans right before the elections. You tell me if it was a smart move. I mean, I see online a lot of people cheering about that. So you tell me if you believe that it was a good move on their behalf, because I guarantee you that there are Republicans families as well who are affected by this. Because the way life goes, when you meet somebody, you don't ask them usually if they're Republican or Democrat, right? You fall in love first and you get married. You may also change your views as to what political party you belong into, and here we go. Afterwards, you reap the consequences of this, that political leadership. So you tell me what you think about this. But for now, what's happening is that USCIS still accepts new applications for parole in place, but they cannot make decisions. They cannot approve new applications. What's going to happen is similar very much to DACA, when if you qualify, you can submit the application, which I encourage everyone to do so, and I will explain why. But you will have to wait for a decision to come a little longer, just because because right now under the court ruling, USCIS cannot grant those cases, even if you've been approved already. If you're one of the lucky ones who got that approval very fast, you don't have anything to worry about. Your application has been granted, you received your benefit, nobody can take it away from you. All right, so just remember that. And if you qualify, don't hesitate, still file. If you're somebody who filed and you're waiting for it to be approved, don't worry. I believe that the program will be unblocked, and I will tell you why. Just for the same reasons I spoke about. Unlike perhaps with children who are dreamers, there is no concern here about the safety or about the fact that these people are totally illegal. Why? Because they're married to US citizens. And they do have other options usually, apart from parole in place options, such as I-61A route or cancellation of removal. It means that the most important reason for somebody to not to agree with this executive order is missing. The public benefit or public de-benefit is missing. Here we're dealing with spouses of US citizens. There is nothing more important in the United States immigration law than the bond between the spouses. Why? Because spouses are they even have their own category, immediate relative category for the immigrant visas. They even have special waivers, automatic waivers under the law. If you're a spouse of a US citizen, you will not be punished for working illegally in the United States, unlike in other categories. You will not be punished for staying visa in the United States, unlike in other categories. So I think whoever files this lawsuit is going to face a pretty tough challenge. But you never know. I have to tell you that the United States is a very interesting place. If you choose the right jurisdiction for your matter, you very well may get that unexpectedly crazy result just because you chose the jurisdiction that is favorable to your cause, meaning that the judge is going to be sympathetic with your cause. And that's the truth of this system. But we're going to see what's going to happen. We're going to see how it's all going to unfold. For now, file the cases. The more filings we have, the stronger our point is that this particular program benefits the United States rather than it does not. All right, this is my principal position. Now, if you guys have your questions and would like to discuss something else, I'll be more than happy to do so. Hi, Duke, watching from Olympia, Washington. Yes, please let me know where you're watching from. Hi, Caesar, super lawyer. Thank you very much. Hi, Farman. Hi, Valdemiro. Let me know where you're watching from. Let me know your questions. Hi, DTP. Is it harder to apply for green card in Republican states after asylum grant? I wouldn't say that. Sometimes it's harder in the Republican states. It's harder to apply for asylum if you are in court. Okay, that's the fact. I'm not making it up. You can open up any statistics on track immigration and you're going to see that. But in terms of administrative filings, I don't think it matters where you are filing from. What matters is your application and consistency. Sometimes I meet these crazy cases where a person won the asylum case in court. A year later or so, they submit for green card and they put incorrect information, either because they lied before or because now they're just careless and they forgot what's happening and they just don't remember or they don't want to remember. Very often, the beneficiary for asylum case, the true beneficiary for asylum case, suffered a particular trauma. They have PTSD. It's hard for them to remember things. They do not want to remember certain things. It's hard for them to organize their thoughts. And that would be excellent if everybody could afford to work with a lawyer. But I meet these cases where a person says, everybody receives the green card after asylum. I didn't think about hiring anybody. Well, they made mistakes in their address history, some other history, whatever. They were called for USCIS interview, and it made it all worse. Because rather than reviewing their previous submissions and preparing for the interview, they again have this position. Everybody gets approved. Why would I need to put an extra effort? It's not a big deal. My asylum case is confidential, right? Well, no, it's not confidential for federal USCIS offices. Any officer can open your asylum case and read it, and they will do so to test you, to see if you're lying or not. And if you cannot answer questions about your asylum application that happened, and I know it may happen many, many years ago, you're going to be in trouble, like this particular person. Got in so much trouble that not only they didn't receive an approval, they are facing removal proceedings. So just keep this in mind. Preparation here, it's an administrative branch of law. Preparation here is everything. Thank you very much for the stars, guys. Those who are watching me on Facebook, please like, share the stream if you're watching me on YouTube, and if you're watching me on Facebook, please, please, please share, send stars, and ask your questions. I'll be very happy to help you out and answer them. Hi, Demo from Virginia. Hi, Andy. I am U visa applicant and I cannot wait anymore. If I go to my country before my case is seen by the judge, am I able to come back to the United States? I'm a Canadian citizen. When incident happened, was overstayed. I don't think you're going to be able to come back if you leave the United States. All right. First of all, Canadians, guys, they don't accumulate unlawful presence times just like regular people. So that shouldn't be an issue by itself. But how would you come back? I mean, you won't have any opportunity to come back. I mean, any reason to come back. So if your case is seen by the judge, you wrote, but most likely your case is pending with USCIS, right? So I think that's what's happening. I would not recommend you to go back to your home country, all right? You can discuss the situation with your attorney as well, but I would not tell you to do so. You also need to know that it takes years for your visa to be granted, for your visa petition to be decided, let's say. So you may find yourself in a situation where you abandoned your case because you left the United States with no opportunity to refile it, with no opportunity to come back. Okay? Don't do that. CAD expedition. It was because now, all right, let me see. Oh, we're discussing the PIP. It was because now they guarantee the House and the Senate, because they control the House and the Senate, maybe. Not sure. But listen, whatever is going on, I think it was a bad move because it affects United States citizens, people who can vote. I don't know. Maybe it was known to unfold this way, but it definitely was a bad move. I think Republicans made a mistake here. Whoever, not necessarily Republicans, all the Republicans, but whoever put forward this lawsuit made a strategic mistake. Hi, the Duke. Hi, Squire. If my US citizen fiance is 27 years and I'm 44, of course, 17 years age difference, would this gap raise flags with USCIS when filing for marriage later? By itself, yeah, maybe, but it doesn't really matter. I had cases where the age gap was way, way bigger than yours. So, what you need to do in this situation, you need to prepare very well. Okay, just prepare very well. And also, both of you are relatively young, right? So 44, 17. I mean, you're still young, 44. It means that, and your fiance is 27, so you may have very good relationship, have a family, children, and everything. So I wouldn't say that it's such a big issue. All right, I wouldn't really focus on that at all. I would just focus on presenting evidence of real marriage more than anything, and that's the only way to approach this. Your age and the age of your partner, honestly, is and not it's not anyone's business. If you want to date or marry an older person, it's your business. If you want to date or marry younger person, as long as it's legal, it's your business. Okay? What is happening here is how USCIS takes all the evidence in the aggregate and they look and make the determination whether as a whole they believe that your relationship is real. Are you saying that you're going to be planning a family, but both of you are of advanced age? And usually people do not have families, do not start having families in this at this age. Well, usually maybe. But then if you have evidence to the contrary to beat up that usual argument, go ahead. Don't worry about this. And both of you, it's not even applicable to you. You and your fiance are both very young. So, all right. Hi, Mr. Alvarez, Juliet Alvarez. I think this is just going to be like DACA. I don't think so. I think it's going to be unblocked at some point. What I would do if I were somebody who would want to unblock it, do you recall how it was with what is it called? With some other executive actions. So sometimes they bring the lawsuit in one jurisdiction, but then there is an opportunity to bring a lawsuit in a different jurisdiction. And then we have this different decisions from two different courts sometimes that are conflicting decisions. So if they want to play this game, I guess if the administration wants to play this game, they can do that. You know? Hi, Damore from Virginia. Yay. Do you think that they will continue, or do you think that they're going to stop it? No, they will continue. Can an asylum seeker daughter seek DACA to help with a college tuition? Now, remember, if a person never had DACA, right? They never had DACA. They can submit the application, but the application is not going to be granted. So, can they seek DACA? Yes, they can, but they're not necessarily going to succeed with it. I do not know how old the child is, but if the child is under 21 years old and one or both parents abandoned, neglected, or abused the child, they may have an opportunity to file for special immigrant juvenile status. Okay? Unfortunately, it takes now also 4 to 5 years to receive green card based on that status, but it's okay Because as soon as SIG is approved, a person gets paroled, has an ability to file for a work permit, and I think once they're paroled, they can argue for that in-state tuition. I may be wrong, but try that. Another interesting thing with young people is that until you are 18 years old in the United States, you do not accumulate something we call unlawful presence. Now, before 18, we don't accumulate unlawful presence. After that, if it's a child of asylum seeker, they're covered with asylum dependent status. And while your asylum is pending, your child still does not accumulate unlawful presence. Why it's important? It's because for many young people here, sometimes there are opportunities for employers to sponsor them. Why? Because, well, a young person who came to the United States with their parents long time ago usually speaks without an accent, has the same mentality as people who are born in the United States. They adapt very quickly. And if they spend here a long time, many people who meet them, they don't even know that they were not born in the United States. Hence, if they start working somewhere, people just offer them the jobs, right? It's easier to get the job. And you may find a person who is 20, for example, and their boss says, "You are so wonderful. I would like to help you out." They later find out they don't have a status and so on. And I would like to help you out. Like, how can we do that and so on? So the point is this. If your young child under 21 does not qualify for SIG, but has an opportunity to be sponsored for work, they will be able to benefit from the sponsorship if they travel overseas and get the visa, as long as they do not have more than 180 days of unlawful presence time. So when you are trying to solve your child's immigration status issue, please keep this in mind, that there is SIG and there is opportunity for employment. Not for everyone, absolutely not, but for some. How many times have I met kids who have who have one parent in the United States? Parent filed for asylum, and the kid could have qualified for special immigrant juvenile status, but they didn't know that there is such a thing, and they missed that opportunity. And now the kid is like 23, and now they're an adult. The only thing that they can do is to marry somebody in the United States if they're lucky and fortunate enough to meet somebody. You see? So DACA not necessarily going to work, because if they never had DACA, it's not going to be approved unless something changed within the past couple days that I did not hear about. I have a friend who was in removal proceedings in 2013 and never left. He recently has I-130 approved. He's married to a US citizen. Can he get removal order cancelled? He also applied for parole in place. He will have to ask for prosecutor to agree to prosecutorial discretion. If they filed for PIP, they may have a chance, all right? They will need to have a motion to reopen, most likely, unless they were arriving alien at the time when they were placed in removal proceedings. My question, if you cross the border in Mexico, can you get a credible fear and your court date is being postponed for 3 times? So many, and you got the credible fear. Okay, you got the credible fear, and your court is being postponed 3 times. All right. So my question, is it possible that you can win the case? Any case, I mean, if you can win the case, asylum case, depends on your qualifications for asylum. Without talking to you, seeing what the case is about, how you qualify for asylum, it's not possible for me to let you know what your chances are. Now, if the case is being postponed for forever, right? Yes, you can ask the court to recalendar it. And I was, for the first time in the history of my practice in 16 years, was finally successful in doing so. I did file a motion in Chicago And it was a miracle. The case was put back on the calendar after like the person was waiting for it for like 8 years, I think, altogether with the initial filing when they were waiting for the interview affirmatively. So it's possible, not so often it happens, but it's possible to expedite your hearing, all right? But if you can win the case, depends on your qualifications. How you are going to win your case. Is it political asylum? Is it religious asylum? Is it something else? Do you have an expert for the country conditions? Did country conditions change at all? Have they changed? Anything else happened? It all depends, all important. Hi, Amina. Hi, Alena. I have a question about detention. My mother is in Louisiana. What are the chances she entered the United States without the CBP-1? This question was presented in Russian, so I will answer it in Russian. All of you guys who do not speak Russian, please, I'm sorry, and just let's be patient. We're trying to help somebody out. Смотрите, если ваша мама сейчас находится в иммиграционной тюрьме в Луизиане, приехала без CBP-1 App, скорее всего, ее не выпустят, пока она не пройдет все суды. Это просто будет невозможно. Если только ей не дадут пароль по какой-то гуманитарной причине, например, по состоянию здоровья, что случается крайне-крайне редко. Обычно люди, которые загребают в Луизиану, это, как говорю, загребают, потому что там, конечно, условия еще те, они, к сожалению, должны ждать суда, пока они там находятся. Хорошим является то, что обычно такие суды проходят довольно быстро, в течение 6 месяцев. Да, звучит ужасно, 6 месяцев в тюрьме, но на самом деле, по сравнению со всеми другими процессами, это довольно быстро. Поэтому я желаю удачи вашей маме. Ей нужно, конечно, очень хорошо готовиться к суду. И, скорее всего, она не выйдет из детеншена, к сожалению. What if you got the appointment for biometrics? Hi, Tamika. For PIP, go for this appointment for biometrics. Absolutely. If you received the appointment for biometrics, you must comply. Do not miss that appointment day. Why? Because this parole in place thing may be unblocked at any moment. You do not want to miss an opportunity. You do not, if you miss your appointment for biometrics without rescheduling, your application will be considered abandoned. So do not miss that appointment, okay? I encourage everybody who qualifies to file. Do not give up. File. The more of us who's going to file the cases, the better it is, because then there is a power in numbers. We can say, look, hundreds of thousands of United States citizen families are going to be affected together with children. If you are going to hold this program and will not allow spouses of US citizens receive this parole, it's not even a visa, it's not even a green card. To get to the green card point, you'll have to file the type 45, you will have to go through motion to reopen, more checks, different standards. It's just the beginning of the journey. So there is no danger to public safety. It's not here. This whole lawsuit is just a joke. A joke. Today, by the way, the President of the United States made a statement on the issue, and they also said it's wrong. The lawsuit is simply wrong. And I absolutely agree. Hi, Tamika. They said they will, on the old biometrics records, they said, okay, so they said that they would reuse your biometrics. And I think I received a notice like that too in one of the cases. So then you don't have to appear if they renew the biometrics. You don't need to worry about that. You just have to wait. What I would do, what can you do in this situation? Well, just wait. For now, just don't make any steps. Just wait. Hi, Javier Ramirez. I had DACA and biometrics taken. I filed for PIP and they said they will reuse my biometrics. Is it possible I can get new social security with parole in place? Guys, new social security number is not going to be assigned to you because you receive parole in place. Social security number is assigned to you once and for all. That's it. You may request Social Security Administration to issue to you a new social security number, but there are strict rules about that. You have to be like in something like a witness protection program, okay? Social security number is yours once and for life. But what you may be asking about is the work permit. If your PIP is approved according to the rules, only then you can file for the new work permit. And if that's what you want, fantastic. But the point of the PIP was to give you that lawful status in the United States, lawful in terms of parole, so that you can satisfy the requirement for adjustment of status and get a green card. Now, you mentioned that you had DACA, I believe. Did you say that? Or did I read it wrong? Yes, you had DACA. You had DACA, or do you still have DACA? Guys, if you still have DACA, you can travel on advanced parole out of the United States and come back, and you have the same parole. And that's how you're going to be able to qualify for a green card based on marriage. You don't even need parole in place here, okay? So please keep that in mind, all right? All right. Hi, Shyam. Will parole in place help my friend with removal order being cancelled? He qualifies for the program and has pending removal. Okay, I think I answered that one. So yes, it will. And even without the parole in place, you can always file motion to reopen sua sponte based on court's own authority. It's granted often, sometimes it's not granted. It really depends who your judge is. Sometimes I'm successful at the stage of the initial stage of the immigration court. Sometimes I have to appeal to the Board of Immigration Appeals. There, I have very good chances usually for the motion to be granted. One denial I had, I don't know why, just somebody who hates immigrants, I say, I'm not going to name the name of the judge because it's not ethical, I say. But it was, that denial did not make any sense whatsoever. So the family has to fight it further, unfortunately, but it happened like literally once out of 9 cases. And I'm telling you the truth. I'm not saying that I win every single case, but we do an excellent job for every single case. So if sometimes you're unsuccessful with a motion to reopen, if it's so sponte motion, sometimes you have to just keep filing it and refiling it. There is no limit on the number of the motions so sponte that you can file. Sometimes you're not successful the first time around, and you refile it after a while, and then you are successful. And there are many lawyers like me. If you don't give up, in most situations you will get the result. But you have to be ready for the fight. You can't, give up and get tired with the first time something didn't work out. Life doesn't work like that. Some people are lucky and everything falls into place for them, and some people have to fight for their life. You comment, you tell me, how was your life? Was everything easy? Did you get the job of your dreams for the first time and partners that you wanted, or did you have to go through different obstacles in life before you actually achieved the result that you're looking for? Just immigration, it shouldn't be this way, but unfortunately it is just like that. Sometimes one-time filing is just not enough. Now let me see questions from Facebook, and I have a ton, and I'm so sorry guys, I neglected you. Let me see. Hi, madam. I have 2 kids in the United States. My boy name is Argentine Gascon. I'm not going to pronounce the kid's name. Working and staying there right now. And my daughter name is Kyle, okay? And on my situation, I hope you can contact them. Oh, sweetheart, I do not know even how to find your children, but this is what you need to know. If your children are in the United States, I hope they have a guardian, okay? If they're under 21, they can get green cards if they're growing up here without parents. And I do not know what your situation is, okay? But you need to know that any child in the United States who is residing in the United States without the company of their both parents should be checked, screened for special immigrant juvenile status. Okay. So hopefully this tip is going to help you just maybe to start your research. All right. Let's see. Thank you very much, guys. Thank you for your kind words. Hi, Farman. Hi, Asrar. All right. Hi, Tesh. Can an overstayed apply for EB2 national interest waiver? Yes, you can apply for EB2 national interest waiver. Absolutely. You can file that I-140 petition. But the better question is whether or not you'll be able to benefit from it once it's approved without leaving the United States. And if you overstayed, most likely the answer is no. Now, knowing that, the question will be which particular status you overstayed. If you overstayed status that was given to you for duration of stay or status, DS, then most likely you did not accumulate unlawful presence time. So consider this situation, and just I'm going to share with you a little example before we're going to say goodnight. Somebody started on an F1 visa in the United States, received master's degree, couldn't find a job afterwards, and overstayed their time in the United States. So they don't have status. They never started accumulating unlawful presence in the United States. Now they filed and they have EB2 national interest waiver petition approved. They have to travel to their home country to receive immigrant visa. And because they never accumulated unlawful presence time, even though they all stayed their F1 visa, they should be able to leave the United States, come to the US consulate, pick up that visa, come back. That would be the plan. All right? That would be the plan unless there is something else going on. And when we work with clients, we always check if there is something else going on that potentially may present this huge issue of person not being able to return back. It's very important to screen the client for all potential dangers. A claim of a U.S. citizenship, God forbid, never call yourself a U.S. citizen if you're not in the United States, or immigration fraud, for example, right? Something like that. Those are the two popular ones. Why you get stuck after you go to your home country for a visa. Well, guys, thank you very much for joining and watching this stream. Thank you very much for liking and sharing. Thank you for your patience. Thank you for your questions. I hope that the issue of parole in place, at least, and what's happening got a little bit clearer. And even though it's still frustrating, especially for the families who really were waiting for this, I truly believe that it will be resolved in your guys' favor. It's just my gut feeling. I don't know, maybe I'm wrong. We'll see, right? You tell me, save this video and we're gonna see what's gonna happen, right? And please sign up, subscribe for the channel, follow me on Facebook, on YouTube, TikTok, and I hope to see you guys soon.